Good evening, members. Myself, CA Chawla. Welcome you all in this today webinar on new code of reassessment provisions, budget proposals 2021. And we are very honored to have with us CA Aseem Chawla ji, a very renowned international faculty on international taxation and Indian taxation. I welcome you, CA Aseem Chawla ji. Welcome,
Thank
sir.
you.
And the silent feature of our today webinars are that new code of reassessment provisions, budget proposal 2021 under the scheme of the Income Tax Act 1961, effective April 1, 2021, the existing provision of section 147 of the Income Tax Act would get overhauled. Revisitation of time limitation period for issuance of notice, and impact of insertion of proposed section 148A. And also, I would like to request all the members attending this our webinar that if you have any query, you please write down your query in our comment box. Our guest faculty will take up all your queries after his deliberation. So with this, I once again welcome you all and request our honorable speaker to please start his deliberation. Chawla sir.
Thank you, Raji, for your continued encouragement. And one of the themes, and I'm straight away jumping to the subject considering the time at hand. One of the important takeaways which affects the tax practitioners in terms of their now going forward faceless interaction with the tax department is how to take up matters which pertain to reassessment and the substantive amendments which have happened in the scheme, proposed amendments, I should say, because the budget is yet not legislated and we don't have a new Bible, so to speak. But if one were to assume that the tax proposals as presented by the Honorable Finance Minister would see through, and it's sad that most of the time we don't find much deliberations in the both houses with regard to tax or money bills. Last year's budget, even during COVID, was a classic example how backdoor entry was made in some of the important uh, finance bills. And finally, when the act came up, we had few far-reaching amendments. But let's come back to the subject. Assuming the budgets finally sees the light of the day, that it is, without making too much of background, I must say that we are looking at a complete overhauling of the reassessment scheme. And although it's being presented very nicely by the Honorable Finance Minister, and if one were to accept or acknowledge the intent of minimum government and maximum governance, which translated into tax policy means a very light touch approach by the tax department, and therefore one of the chief highlights or selling points of this budget has been that the limitation period of going back is now getting reduced substantially to 3 years, and only in cases where approval is sought, one is looking at a period of 10 years. All this is very nicely presented. I'm not trying to be uh, too much carried away by the rhetoric. And if one were to look at things from a balance as a practitioner who is the bridge between the tax department and the taxpayer, I think it's a very daunting task, which is premised by one important consideration. Should these provisions be leveraged when it comes to meeting targets and pushing the boundaries? And I don't want to use the word coerce the taxpayer, but if we are really pushing the envelope and trying to corner the taxpayer and not giving finality to completed assessments, then I can tell you, Raji, we are looking at a floodgate of litigation in the faceless regime, and that's the red herring which these new provisions do bring up. As I said, this is all predicated on the fact that how the tax administration puts into service the provisions which get legislated. वो इतना एक टूल हाथ में मिल जाएगा टैक्स डिपार्टमेंट को कि अगर उसका उसका यूज ठीक तरीके से, व्हेन आई यूज द वर्ड ठीक मींस इन अ जुडिशियस वे, ना किया जाए, if it is not if these provisions are not put into service in a fair manner, then I'm telling you the scales are so evenly tilted if one looks at the new scheme of reassessment. So this is the broad background. May I request if you could just turn on the slides, and they are available for your viewers and esteemed delegates and seniors. I mean, I'm sure you can provide them upon requisition. And there is a very nice article which my office has sent to you, which I authored yesterday, which I sincerely believe brings out the challenges in this new code of reassessment. So let's have the slides, please, Raji. Yeah, thank you very much. One request I have to all the delegates who are present is that either they should have the finance bill with them, or they should have the Income Tax Act, because we are trying to do somewhat of a comparative analysis of what the proposed provisions are and what the provisions currently stand out. So in terms of today's menu or schema, we will have the new scheme. We will try to understand how the new finance bill aims to substitute or represent the reassessment provisions. We'll try and do some quick comparative analysis of the present scheme with the proposed regime. Then, of course, we all understand that Section 147 has been substituted. 148 has been substituted. 148 is a new insertion in the scheme of reassessment. We have a new time limit, so 149 gets substituted, and then we have provisions which are administrative but very important in terms of ensuring checks and balances. And this is exactly what the finance minister was trying to impress during the budget speech, that the checks and balances would be fairly judiciously exercised, especially in the case where go back provisions are going to be issued in cases of a period of exceeding 3 years, but not beyond 10 years from the end of the relevant assessment year. And also a collateral fallout, which of course we can discuss on any other day, is what happens to the impact of these reassessment provisions vis-a-vis search, because we all understand that in this budget, the special assessment provisions relating to 153A capital to 153C capital dealing with search have been done away with, and the normal provisions of assessment and reassessment, as the case may be, would be applicable to search. So very briefly, we will discuss. I know this is a subject which requires attention and deliberation on its own at a given point in time. Raji, I'm aware of the fact that this is one of your well thought out subject also. We will certainly deal with this in the coming weeks as we progress along. And then finally, what are the key considerations which we've been able to pen out together? I'll be failing in my duty if at the outset I don't thank my two very industrious colleagues, young Pulkit and our seasoned Mr. Manu Giri, who have really brought out their thoughts in terms of deliberating on this subject. As I said, this has some far-reaching consequences. Next slide, please. So, what is that we have now? As I said, we have a new 147, a new 148, a new 148A introduced for the first time, a new 149, 150 stays as it is, so there is no change. 151 capital A brings the faceless regime into the reassessment proceedings, and then of course we have time limit. So this is how the current new scheme of reassessment will look like, the way it is presented by the finance bill. Again, hoping that this, of course, I mean, by the time we end our deliberations, we all hope that this should not finally see the light of the day the way it is being currently proposed to be legislated. But assuming it gets legislated the way it is, because we have all seen that in our parliament, budget hardly gets debated in the measure as a tax practitioner or a taxpayer would prefer. So reassessment provisions have been a very evergreen, controversial subject, more so in the recent past. Next slide, please. More so in the recent past, when you found in the backdrop of demonetization, penny stock, fake invoicing. So since 2016 onwards until date, we've had more reassessment proceedings than ever before, and that is a testament to the number of reported decisions you will find of various high courts dealing with reassessment provisions. So the increased incidence of pressing into service these provisions at the instance of the revenue does make at least some of us nervous if now the phenomena would remain the same in terms of the incidence. अगर इतनी ही रीअसेसमेंट प्रोविजंस या इतने रीअसेसमेंट होते रहे, और अगर ये नया स्कीम इनकम टैक्स डिपार्टमेंट के पास है जिसके तहत वो रीअसेसमेंट करेंगे, तो फिर आने वाले दिनों में रीअसेसमेंट तो बहुत रीअसेसमेंट के नंबर्स बहुत ज्यादा इंक्रीज होंगे, एंड टू मी इट विल बी simply a one way street. And why I say so, let's look at next slide, and then I'll build on a few important themes. So let's not forget what GK and Driveshaft said to bring the manner of fairness. GK and Driveshaft is a judge-made law, 259 ITR page 19, and you will find now finally some semblance of this old 2002 decision, almost after 19 odd years, gets somewhere reflected or codified in 148 capital A, जो नया प्रोविजन आया है, बट पूरी तरह नहीं है. बट अच्छी बात है कि 19 साल लगे इनकम टैक्स पॉलिसी मेकर्स को रिकॉग्नाइज करते हुए कि जीके एंड ड्राइवशाफ्ट को कोडिफाई कर दिया जाए. GK and Driveshaft dicta was very simple, that well, you need to pass on the reasons which you have recorded. So A, reasons must be there pursuant to which you believe that income has escaped assessment. So if reasons are there, they must be recorded, fair enough. And whether those reasons have been passed on to the taxpayer, and then the assessee is bound to furnish the reason within a reasonable time, and the having received the reasons, the assessee is entitled to file objections to the issue of notice, and the OA is bound to dispose of the same before passing before really passing or initiating the reassessment proceedings. The only prerequisite is that the assessee is required to file a return. So very simply putting in the life cycle, notice आया, आपने कहा कि please treat the return filed earlier as return in good compliance of the notice, or you file a return, then you have all the legitimate right under the sun to ask for the reasons which have been recorded, and the AO is duty bound to give you the reasons which have been recorded. As an assessee, you have a right to contest the veracity of the reasons and to file your objections to the fact that if on those reasons assessment is getting assumed, in other words, the AO is going to assume jurisdiction to reassess basis those reasons, then as an assessee you have all the right under the sun to contest by filing your objections, and he is duty bound to dispose of, and then proceeds with the reassessment. So this is one important pillar of reassessment provisions. Now 148 legislates it somewhat. We'll discuss that. Then, very recently, in the case of NDTV, and some of the delegates and the viewers present may recollect, during lockdown, this was one important reassessment decision dispensed by the Honorable Supreme Court, which Rajji was very kind enough to allow us to share our views, and we've done a complete discourse on the NDTV judgment. Now, NDTV's judgment is important for the proposition in the context of full and true disclosure, that the obligation of the assessee is to disclose all primary facts before the AO, and he is not required to give any further assistance to the AO by disclosure of other facts. It is for the AO to decide what inference it draws. And the court went on to hold that non-disclosure of other facts, which may be termed as not primary but secondary, is not really necessary. And then we all understand that proper reopening in the manner provided under the law has remained wanting. In other words, more often than not, or in very many cases, we've found that reopening has not been done in accordance with law, and the courts have time and again admonished or expressed their grave concern and anguish that proper checks and balances have not been adopted, and therefore you would find instances where reassessment notices or the factum of assumption or purported assumption of jurisdiction has been that particular act, and those notices have been quashed on the issue of proper exercise of jurisdiction. Now, let's come to the next slide, and let us compare the present and the proposed regime insofar as 148 is concerned. Then we'll come back to 147. So, old scheme, very important. Remember, everything in the present scheme or the old scheme जो अब replace होने जा रही है, as things stands in the existing scheme of reassessment, the gateway or the fulcrum or everything predicated upon reasons to believe. Now, it is disappointing that a settled law which has withstood the test of time for so many years, I mean, for those of you who are testament to the amendments which were made in 1989, would recollect the fact that reasons to believe were at that point in time proposed to be omitted, but on various representations they were brought back, and a 31 odd year old law, which has now judicially being settled by a stroke of pen, you just want to change it. Now, under the new scheme, 148 can be issued where the assessing officer has information which suggests that income has escaped assessment. So, reason to believe ka koi zikr nahi hai. We'll deal it extensively in 147 in the subsequent slide. I just wanted to help you with a comparison on the entire procedure and how the present and the proposed regime would look like. Now, in the existing or the old regime, which is going to get replaced or proposed to get replaced, reasons had to be recorded that income has escaped assessment. Now, following or taking a clue from the GK and drive shaft 259 ITR doctrine, the process has been laid down in 148 capital A. The AO has to conduct an inquiry, grant an opportunity of being heard, consider reply, pass an order, and then initiate the proceedings. Very well. Sanctioning authority and the time period. Let's scroll down. Shrishti, can you just help with the slides, please? Yeah. Up to 4 years, Joint Commissioner. After 4 years, Principal CIT of Chief Commissioner, or 4 to 16 years. You know that in case of foreign interests, the law of reopening was amended to take care of such situations, and the law would go back to almost 16 years. So time limit 4 to 16 years. Now time limit is 3 to 10 years. This is the selling point of the finance minister, that we don't want to keep the assessee in an uncertain situation. So now it is 3. In exceptional cases, will be extended up to 10. Time limit, there is no change as such with regard to the uh, completion of assessment reassessment proceedings is concerned. Yes, overall we all understand that as part of the faceless IT digital exercise, the overall time frame of both issuance of notice and completion of assessment is being truncated. And if you look at the time frame given for the succeeding assessment years, धीरे धीरे करके time कम किया जा रहा है. Right, let's move on to the next slide please. Now, this is the heart and soul of the entire reassessment provision, which predicates upon 147, the gateway of reassessment proceedings, and stands on one important pillar, which is reasons to believe. Assessing officer must have a conviction that there are reasons to believe that income chargeable to tax has escaped assessment. And then there are some deeming provisions which you will find in the scheme of the act, which suggests that income has escaped assessment, which you will find in explanation 1 to uh, which you will find in explanation 2 to section 147 of the Income Tax Act. I mean, if you have the act handy with you, it's fine. Otherwise, you can probably look at the finance bill and then can try and compare the provisions with the existing provisions of 147. So explanation 2 to section 147 says that for the purposes of this section, following shall also be deemed to be cases where income chargeable to tax has escaped assessment. Fine. And then assessing officer, in terms of the uh, third proviso to the existing 147, may assess or reassess such income other than the income involving matters which is chargeable to tax has escaped assessment. ये तो law जो है अभी statute में, the one which exists in the statute, what it reads. Now, what is being proposed? Now, let us look at the drastic changes which are being proposed. Now, if you turn around to finance bill, and the relevant clauses for your benefit are clauses 35 to 40 and 40 to 43, 35 to 40 and 42 to 43 of the finance bill, effective 1st April 2021, you have a new 147 which is being substituted, and this is what the new substituted section, assuming this sees the light of the day, would look or read as follows. Yeah, let's scroll down the slide a little bit. Yes, I have underlined, although it's not a good I mean, in terms of formal learnings of PowerPoint, that you should underline your slides. This was one of those learnings given by those fancy experts who come and help you with your presentation tricks, but still I have deviated, and there are some red lines underlining you will find just to help you in drawing a comparison. Now, if there is any income chargeable to tax in case of the assessee which has escaped assessment, the assessing officer, subject to provisions of subsequent sections, assess or reassess such income. Fine, but where is reason to believe? There is no concept of reason to believe in 147, and this is the game changer in my view. And if not administered fairly, could lead to some very undesirable collateral damage. And then there is a convenient explanation that the assessing officer may assess or reassess income in respect of any issue. ये this issue is also a new creation of these new provisions of reassessment. All along, you read the income tax provisions dealing with reassessment and otherwise, you will find a phrase known as matter. Now, maybe the word issue is so popular in our daily lexicon that we can't complete a sentence without using the phrase issue. This issue has now found its perhaps rightful or justifiable mention in the tax provisions, the way sections are being drafted. So instead of the word matter, now the scheme uses the word issue, and I'm sure there will be enough judicial controversy as to what the word issue means and whether this assessment is in respect of a issue or a non-issue, or when something becomes an issue which would yield in a situation of assessment or reassessment. Anyway, for those of you who are mapping the provisions, this explanation to the proposed 147 is similar to, I will not use the word parameteria, but it is similar to the third proviso to section 147 as it exists just above explanation 1. So, I mean, no reasons to believe. The gateway to 147 conveniently drops the time tested, judicially interpreted that जो पहरेदार है, the gateway is reason to believe, and you are getting into reassessment proceedings. 147 is the gateway, the threshold is reason to believe. Reason to believe is conspicuously absent in this situation. Now, whether it is by intent or it is to ease out, to me, it demonstrates one simple, amongst others, amongst several takeaways, one simple takeaway that the tax policy just does not have the does not believe that it has the conviction in the tax man's ability to formulate reasons, because whatever he does, maybe at the high court stage, the pack collapses. Remember, issuance or aiming to assume jurisdiction, an act of assuming jurisdiction under 147, under reassessment proceedings, by virtue of invoking these provisions, are only justiciable in a writ remedy. There is no appeal provided as an appellate remedy under the scheme of the act. So any act of assuming jurisdiction under the reassessment proceedings is only justiciable before high court in a writ matter, and therefore, in the absence of any alternate remedy, the only recourse available to taxpayer is to knock the door of the high court. And it will be very interesting to see that how the high court will now uh, dispense and be able to ensure that justiciability is done to the provisions of 147, because there are no reasons to believe what the act does provide. Let's move on to the next slide and consider. Yes. Now, under the existing provisions of 148, and somebody may have a question at this point in time, that is that all which is there in section 147, what we discussed? Yes, the answer is that is all in 147, and all that the explanation to 147 provides. Let's go back to the next previous slide, please, just for a minute. Yeah, all that the new 147 provides is this, and along with this is the fact that reference of 148 capital A is there in this particular explanation, but it doesn't alter the fabric or the contours or the fundamental provisions of 147. Ab 147 सिर्फ इतना ही है. This is exactly what the long and short, and what is the outline and the mainframe of 147, which is, I mean, the least to say sounds disappointing. Anyway, now 148. Yeah, let's move on to slide 7, please. Next slide. Now, the existing provisions of 148, the way they stand currently now, the AO is mandated to serve a notice requiring an assessee to furnish a return, and the assessing officer records his reasons for issuance of notice. Now, what is being done now? A brand new 148 will substitute the existing 148. And what it says is that before making the assessment or reassessment, and subject to provisions of 148 capital A. Now, this is new and important. The assessing officer shall serve on the assessee a notice along with copy of the order passed if required under clause D of 148 capital A. So before he does an act of issuance, an act of proceeding with the assessment or reassessment, the assessing officer shall serve a notice. Along with the notice, he will serve a copy of the order passed under clause D of 148 capital A. So 148 capital A perhaps is the new gateway, but may not be as efficacious in the alternative as 147, but it is a gateway before 148 motion is put into service, before the ball starts get rolling in 148. Before a notice is issued in 148A, he will have to serve a copy of the order passed under clause D of 148 capital A. And of course, once he issues the notice, he would requisition the taxpayer to furnish a return of income or return of income of any other person in respect of which he is assessable under the Act during the previous year, verified in the manner so and so stated. Now, then there is a proviso to section 148. The newly proposed to be substituted 148 has a proviso. It says that no notice shall be issued unless there is an information with the assessing officer which suggests that income chargeable to tax has escaped assessment. Earlier present regime, he must have reason to believe that income chargeable to tax has escaped assessment. What is being proposed? There is information with the assessing officer which suggests that income chargeable to tax has escaped assessment. The whole concept of formation of belief stands now relegated to a situation where if there is some information which is suggestive of the fact that income has escaped assessment, then only a notice can be issued. Then there is an explanation to section 148, which is explanation 1. Let's scroll down the slide a little bit. Now, explanation 1 says that for the purpose of this section and 148A, the information which suggests that income chargeable to tax has escaped assessment means these two kinds of information. But there is a situation where there is income chargeable to tax which has escaped assessment. Fine. Now, how do you proceed? You must have some information which suggests that income chargeable to tax has escaped assessment. Now, the law is trying to explain what could be those two situations. Remember, explanation 1 says for the purpose of this section and 148A, there is an omission of section 147 in this explanation, which could have some serious consequences. Because as I said, 147 is the gateway, and what is income escaping assessment is not 148, it is 147. 148 only suggests the issuance of notice. Therefore, it is subservient to 147. In substance, you would initiate a notice under 148 when there is a case of income escaping assessment which has been described in 147, and information which suggests that income has escaped assessment refers to 148 and 148A. 147 still reads, in case of an assessee where income has escaped assessment for any assessment year. I think it would be helpful if we could quickly, go back to 147 and just have a look at 147. Let's go back to 147, please, for a moment. Let's go back. Quickly have a look at 147, please. Yes. The proposed substituted 147 says if any income chargeable to tax has escaped assessment. This is not defined in the explanation to section 148, explanation 1, which we just saw. Let's come back to the explanation again, Shrishti. Yes, explanation 1. It says information with the assessing officer which suggests that income chargeable to tax has escaped assessment means these two following situations. What is income chargeable to tax has escaped assessment? This explanation is silent. The two situations which are being conceived are A, any information flagged in the case of the assessee for the relevant assessment year in accordance with risk management strategy. Now, for a moment, I am just thinking aloud as to when the reasons are put before judicial scrutiny. We all say that reasons must be justiciable because they can be assailed before a writ court. How one would conceive a risk management strategy related information as justiciable before the court? What kind of that in risk information strategy which will throw up some information? At the end of the day, it is not that the courts will refrain from exercising their plenary powers and indulge in matters where extraordinary powers will be sought indulgence. After all, there is no appellate remedy still. If one reassessment provisions and jurisdiction is being assumed in the absence of any efficacious remedy, I will knock the door of the High Court. And I would tell the High Court that now there is no concept of reason to believe. So he can only proceed when there is an information which suggests that income chargeable to tax has escaped assessment. Fine. What is that information which is being flagged in the case of the assessee? Some flag will be put up in accordance with the risk management strategy formulated by the board from time to time. So that risk management strategy has to be objective. It should pass the muster of judicial scrutiny, right? And any final objection raised by CAG to the effect that assessment in the case of the assessee for relevant assessment year has not been made in accordance with provisions of the Act. Here I have a grievance. The Honorable Finance Minister says we want to give certainty, we want to give finality. 3 years is sufficient. Fine. Minimum government and maximum governance. Fine. CAG audit does not take place very instantaneously. There is a sufficient time lag when the final objections are raised by CAG. I have been in government related enterprises for long, and I know how much time the CAG takes, though meticulously, but it takes its own time and coming out with final objections. And when the final objections of CAG will come, and in a case of a particular assessee, if the CAG says that the assessment has not been made in accordance with the provisions of the Act, that is an information which suggests that income chargeable to tax has escaped assessment. So whatever CAG says, maybe it's gospel. I don't want to now burden you with situations of derived information and audit objections, blindly relied, does not constitute valid reasons. There is enough jurisprudence on that, enough case law on that. We are not doing case law manthan here, but the idea is to understand the law on first principles. Need be, we will do that also on another occasion. So CAG's final objection will be in a way supreme, and they will eclipse any thoughts which the assessing officer may have. So they will sit in judgment, and if there is a final objection, that's an information. So these are two instances of what the information with the assessing officer which suggests income chargeable to tax has escaped assessment. Friends, we must get into this habit of iterating this line very quickly. Earlier we used to say income chargeable to tax has escaped assessment. Now we need to get into this habit of saying information with the assessing officer which suggests that income chargeable to tax has escaped assessment, right? And these are the expression used in explanation is means. So I'm sure judicial exposition, and I can't preempt that, would suggest that this merely is illustrative in nature. It is not it is inclusive, and by no means this is exhaustive prescription. Then there is another explanation to section 148, which is explanation 2. Yeah. Can we move on to next slide, please? Yes. Now, in the following cases, per the explanation 2, the assessing officer shall be deemed to have information Okay, my apologies. There was some connectivity thing. I just hope this whole faceless regime backed by technology works well. Raji, am I audible?
Yes, sir, you are audible.
Raji, am I audible?
Yes, sir, you are.
Okay, great. Thank you. Let's come back, and sorry for this little outage. So, We were looking at the second explanation to section 148, and the second explanation talks of situations of search and survey, which we have tabulated. And in terms of provisions of section 148, the new provisions read with explanation 2, in case where search is initiated under 132 or books of accounts are requisitioned on or after 1st of April 2021, as I said in the opening statement, that the assessment related provisions of search have again been amended. The substantive provisions of search remains same. So 132 is not changing. Reasons to believe is still very much there in 132, thankfully. But the assessment related provisions, the special assessment provision under 153 capital A and C, are being done away with in respect of search which shall be conducted on or after 1st of April 2021. So to, and they will be now assessed as per the existing, as per the provisions of the act dealing with assessment or reassessment. So now that we are getting a new scheme of reassessment, right? And if there is a situation pursuant to search that you have to go back to past periods, explanation 2 drafts that situation in and suggests the fact that where a search is initiated on or after first day of April 2021 or a survey is conducted, then the assessing officer, with the prior approval of principal commissioner or commissioner, can proceed. So this explanation 2 pretty much brings the situation of operationalizing the assessment related provisions pertaining to search and survey. And in these situations, there is a deeming provision to the effect that in such situations of search and survey done post 1st of April 2021, then in such situations, it will be deemed that the information which suggests that income chargeable to tax has escaped assessment. In other words, for non-search, non-survey situations, you will again have to rely on the information suggesting that that income chargeable to tax has escaped assessment. For search provisions, you will deem that the income chargeable to tax has escaped. You will deem that there is an information with the assessing officer that income chargeable to tax has escaped assessment. In search and survey cases, there is a deeming fiction which is being brought in, that you don't have to then the assessing officer does not have to really go and bring forthwith that this is the information which is suggestive of the fact that income chargeable to tax has escaped assessment. Paraphrasing it, search and survey deemed that there is an information which suggests that income chargeable to tax has escaped assessment. This is what the law aims in doing in case of search and survey cases. Of course, the law in explanation 2, clause 2, which deals with survey, clause 3, which deals with AO, talks of satisfaction, approvals of principal commissioner, that the information, that the monies bullion belong to the assessee, and similarly books of accounts also relate to the assessee or any other person. But this is all post 1st April 2021. This is exactly what is tabulated in the given slide, please, which is slide 8. Yeah. Let's move on. Yeah. Let's move on to slide 9, please. We deal with the new section, the 148A, which draws some inspiration from GK and drive shaft, but in a curated manner. Now, as we just deliberated, that provisions of 148 suggest the fact that the assessing officer shall serve a notice on the assessee along with the copy of the order if required under clause D of 148. So So what is 148A? Now, 148 is a brand new provision. It says the assessing officer shall, before issuing a notice under 148, remember this fact, conduct any inquiry if required with the prior approval of the specified authority with respect to information which suggests that income chargeable to tax has escaped assessment. B. Provide an opportunity of being heard to the assessee with the prior approval of the specified authority. For that, we will come to 151, more like the sanction situation which we have currently in 151. By serving upon him a notice to show cause within a given period, not less than 7 but not exceeding 30, on the basis of application on this behalf as to why notice under 148 should not be issued. So show causing why 148 notice should not be issued on the basis of information which suggests that income chargeable to tax has escaped assessment in the case of a given relevant assessment year, and the results of the inquiry conducted in clause A. Clause C says, consider the reply of the assessee in response to the show cause referred to in clause B, which we just saw. And then in clause D is the decision making. This is the order which is referred to in 148. Decide on the basis of material available on record, including the reply of the assessee, whether or not it is a fit case to issue a notice under 148 by passing an order with the prior approval of specified authority within 1 month. Now, the revenue can very well justify that all the noise being made with regard to taking away the reason to believe, tweaking 147 is counterbalanced with introduction of 148 capital A. But to me, it doesn't really subserve the purpose. Remember, GK and Drive Shaft 259 ITR did suggest the fact that you must provide the reasons once the initial compliance of return filing is done, and those reasons must be communicated. Failure to communicate is certainly not a procedural infirmity, it is illegality. Everything gets squashed. You've seen several orders where non-provision of reasons have resulted in collapsing of the entire reassessment provisions proceeding. So therefore, to say that 148A is pretty much an efficacious substitute of the tweaking done in 147, I don't think that any student of law would get convinced on that. I mean, you already had existing 147 and the GK and Drive Shaft doctrine. Now you are tweaking 147, chopping it or taking the hands away and saying that we have brought in the GK and Drive Shaft doctrine in a manner which was already there. It was a judge-made law, was being followed or was supposed to be followed diligently. And let's admit that in more often than not, it was being followed also. So what is that incremental safeguard which 148A now provides in counterbalancing the whole situation? I think on that count, the revenue can make a lot of rhetoric. These are good statements or good Twitter points. But in substance, anybody who is looking at issues of assumption of jurisdiction on first principles may just not agree with it. So this is with regard to 148A, the new procedure. Let us look at the proviso to 148A. Let's run down the slide, please. Yeah, of course, provisions of 148A shall not apply in case of search cases. So this is what the proviso carves out. So the GK and Drive Shaft doctrine or the 148, the whole threshold of notice, reasons, objection, passing off an order, and then invoking 148. If there's a search case, pretty much you are short-circuiting the process of 148A. Now, let us come to the time limit for issuance of notice. Again, we have a newly substituted section, a brand new 149, and let's see what 149 says. Let's come to slide 10, please. So existing provisions was 4 to 16 years, as the case may be. Proposed amendments, uh, we've tabulated for you. In general, no notice be issued if 3 years have been elapsed from the end of the relevant assessment year. Scroll down, Shruti. And where the assessing officer has evidence in his possession that income escaping assessment, is or amounts to 50 lakhs or more, then notice can be issued beyond a period of 3 years, but not beyond a period of 10 years. Now, what is income which has escaped assessment? Let me read out 149 subsection 1 clause B. It says if 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in its possession books of accounts or other documents or evidence which reveals that income chargeable to tax in the form of an asset, please underline the word in the form of an asset, which has escaped assessment amounts to or is more than 50 lakhs or more. Now, what is represented in the form of an asset? Section 149 does not describe it. The entire scheme of the new reassessment regime does not specify it. If at all you need to take clue, go back to 153A explanation 2, which suggests or uses the same phraseology represented in the form of asset, but section 153A will be eclipsed and will not be put into service effective midnight 31st of March 2021, because the special assessment procedure related to search are being done away with. So the closest to find a comparative analogy within the scheme of the act would be to take refuge of the explanation 2 to section 153A to understand that what is the income chargeable to tax in the form of asset which has escaped assessment. So if what if the asset is not anymore in existence? The same conundrum we are finding in the case of Black Money Act. The UFI Act deals with undisclosed income and undisclosed assets and undisclosed income in the form of assets, and the fact that the income declaration scheme was with regard to the undisclosed assets. So the same challenge which we are finding, the way the fiction is being read in terms of assets being crystallized as income uh, in the Black Money Act, the same challenge we will have, that what would be the situations where income which is represented in the form of asset has escaped assessment. What if that asset is no more in existence? I mean, section 72C or something of Black Money Act, resonates such situations. I had an income in the form of asset, the asset has dissipated. So let's move on now. Section 150, as I said, does not change. So thankfully, there is no change in 150. On an illustrative basis, we've tried to give you a rundown of how the limitations of issuance of notice would pan out for these upcoming assessment years. So this slide is a useful ready reckoner situation for yourselves. So have a look at this slide. In the interest of time, I will not take up this slide. It's quite self-explanatory matrix given to you in terms of ready reckoner of the dates with regard to the time limit for issuance of notice under 149. Now let us come to a newly substituted section, which is 151. Slide 12, please. So if 3 years or less than 3 years have elapsed, then principal commissioner or principal director If you are talking a situation where more than 3 years have elapsed, then you are talking at a principal chief commissioner or director general. Now, the finance minister did make a mention of the checks and balances of 151. There are umpteen number of decisions where we found that in the present reassessment proceedings, when we have assailed them before the competent court, that for 151 there must be speaking order, the word sanctioned or approved is not sufficient, it must be speaking in nature, and we found enough deficient situations. And tell me one thing, I mean, let's hold this for ourselves. How much confidence we have in administrative ability of justiciability? In other words, do we have our confidence in the administration with regard to ensuring fairness? Isn't it a ground reality that the administration has always leaned in favor of the tax official rather than the taxpayer? If the administrative remedy is efficacious and genuinely, inherently, consciously, efforts will be made to ensure that sanction will be issued as an exception and not as a norm, then one may find 147 provisions of reassessment being put into service where they are due, where they probably deserve, where the facts do deserve a situation. But if the assessments have to be revisited, and God forbid 151 should be a situation, quote unquote, just merely a procedural formality. I don't want to relegate it by undermining the good offices of senior functionary by using the word rubber stamp. But if they are will be if sanction is forthcoming as a fait accompli, then the revisitation might just become a norm. Why? And I had kept this towards the end, but let me sort of bring it up because we will be shortly wrapping up the entire deliberation for the day. The whole proviso, the famous first proviso to uh, section 147, where we had case of completed assessment, and how completed assessments were taken up with a higher level of thresholds. If all of you can go back to your Income Tax Act and look at the first proviso, which clearly states that where assessment under 3.3 have been done, no action shall be taken after the expiry of 4 years from the end of the relevant assessment year, unless income chargeable to tax has escaped assessment on part of the assessee to disclose fully and truly all material facts. Wasn't that a great threshold which revenue had to climb a big mountain, where 3.3 assessments, scrutiny assessments were done, right? And failure to disclose material particulars was something which the department had to prove. I mean, I don't have to take you to all the pronouncements, the Kelvinators of India, Supreme Courts of the world, so on and so forth. You've done away with the proviso situation. You've done away with the fact that there is no qualitative difference between a fact that a subject year was a subject matter of 3.3 or no 3.3. You've done away with the fact of reasons to believe. Right? So the level playing field ain't there anymore. Of course, how these sanctions will be accorded, only time will tell. The intelligible differentiation for 16 years, you had situations of financial interest outside India. There is no mention. Of course, one can argue that from 16 we are come down to 10. So all these things do suggest the fact that there is tremendous reliance on the administrative dispensation of sanction under 151. Next slide, please. So for search, we have already had a quick review. The existing provisions of search assessment suggested that 6 years, and in certain cases, assessment could be made up to 10 years. And this is the second explanation to 153A, which I was referring to, where income chargeable to tax represents the assets. And then conventionally, the assessments or reassessments in progress would get abated. And now the proposed amendment is such that 153A to C is done away with. 147 or normal provisions of assessment would be applicable to search matters. Now, for search, we all understand that department has been toying with situations. 2003, you had the famous taking away of Chapter 14B, the block assessment concept. From 2003, you've had a situation of 153A to C up until now that you're also taking away. And within that process, the innumerable amendments which 153A to C belonging to, related to third party satisfaction, so on and so forth, did take place. So, I mean, we don't want to make sure a situation that the law is settled, matters travel up to Supreme Court, they take about a decade and a half, we get a fair sense of what the contours of law are, and now that is done, got a new regime altogether. I mean, so this is with regard to the impact on search assessments. Let's move on to the next slide, please. So just to build on to what all we have discussed, and the idea was today to give you a basic introductory primer and help you acclimatize with the new regime and give a comparison of the old regime. So first and foremost, the impact of doing away with the settled concept of reasons to believe. I mean, it pains for somebody who is close to the subject. When you read the settled judgments, and how by a stroke of pen, you've taken away the entire regime of 147. I mean, Delhi High Court, Atul Jain 299 ITR, mere satisfaction of AO4 notice is not enough. There must be reasons on record which led to a belief that notice should be issued after a foundation based on information is set up. There must be still some reasons which warrant holding of a belief so as to necessitate issue of notice under 148. Then you have Gajendra 305 ITR 161 Punjab, Greater Noida 379 ITR 14. You have decisions of GS Engineering 357 ITR 335 Delhi. Recording of reason is a condition precedent to invoke jurisdiction under 148. Now, what is my conviction? Not reasons to believe, but information which suggests. Look at the meek nature. Look at the weak, wobbly, suggestive. Information which suggests. Do you find a conviction? Is it firm? Sort of a weak thing. Information which suggests. No, there is no definitive resolve in the phrase. Information suggesting income has escaped assessment, and you want to go back and revisit the past years. So look at the very low threshold, right? As I said, income chargeable to tax has escaped assessment stands omitted in new 147, and situations which we saw only relate to 148 and 148A when they pretty much describe these situations of what is the information which suggests that income chargeable to tax has escaped assessment. First proviso to 147 does not find mention in the new scheme. Instead of the word matters, we are using the word issue. This will throw a lot of litigation up. Now, whether it will be leveraged and sometimes you try and find one technical point and try and overcome the larger issue. I'm sure this will be leveraged. What is the relevance of change of opinion now? The whole theory and innumerable guidance and plethora of tax literature spent on change of opinion. Uh, I at this moment one has to just question that how the new code and the entire utility of the dictum of change of opinion. The first proviso to 147 I've already discussed, and therefore the entire efficacy of the revenue to discharge the burden that there is a failure to disclose all material facts and particulars, and finally the judicial exposition of information suggesting income escaping assessment. Uh, well, maybe it will take about 7-10 years for some definitive view to come out on this, and by the time it comes, either this reassessment provisions which are staring at us to be introduced in 2 months' time, after 10 years, may find way for something else. So I thought it was a settled law. I mean, it is very ironical that reasons to believe were omitted in the Amendment Act 1989 and were reintroduced by the Direct Tax Amendment Act 1989, and they were brought back. I hope, Rajji, through your illustrious platform, if North Block is listening, I think the history should repeat itself. And the way in 1989 these provisions, after initially getting dropped, were brought back in the Amendment Act, I think in the deliberations to the finance bill, some better sense prevails, and somehow the checks and balances, which are far more than merely giving a sanction, uh, may find just uh, may find its place back in the amendments to the finance bill. I mean, it's wishful thinking, but we all are hopeful. Uh, Time permitting, maybe in the coming weeks or something, we can have a look at the real impact on the assessment related provisions of search and survey, with the reasons that now they form part of the ordinary provisions of the act. Uh, but this is what the new package of reassessment provisions is in store, and a very heavy burden lies on the administrative part of tax policy to be able to ensure that these provisions are used in the most fitting case. Let's not forget that in the absence of any alternate remedy, these will be again tested before a writ court. And even the order passed under 148 subclause 1D, I was looking at the fact that whether any contemporaneous amendment has been made in 246 capital A dealing with income tax appeals before first appellate authority. It's not there. So pretty much in all likelihood, we will find that those interim orders will also be subject matter of uh, writ remedy, and will be assailed before the High Court in times to come. So with this, I rest my thoughts for the moment, and my apologies for that 2 minutes outage which we had on account of internet. And the only thing which I need to suggest the fact that in 151, the issuance of notice under 148 and 148A has now been brought about, which does suggest the fact that for faceless purposes, they would be in place. With regard to 148 capital A, I think let's just have one quick round, and if we can have the relevant slide back again on 148A, There are two or three interesting things which I thought I'll just take through. Let's go to slide 9, please. Yeah, slide 9. Yeah. So when you look at clause A and talk of conduct of inquiry, would the assessee be participating in this exercise? I'm not very sure. Uh, if you look at clause C, consider the reply of the assessee and in response to the show cause referred to in clause B, will the show cause be very detailed out, or still it will hold something, some aces up the sleeves of tax department, which perhaps is not known, and as I said, the interim order passed in clause D, which is the prerequisite of issuance of notice under 148, is not appealable. And then when we come to the proviso dealing with such matters, if we scroll down a little bit, the whole aspect of satisfaction is still forming part of the scheme of search provisions. So thankfully, right from the 150 BC Manish Maheshwari doctrine, and the law has certainly evolved on 153C, and there are many contemporaneous judgments. I think they should still hold good, because they talk of satisfaction, and satisfaction is a quasi judicial act. So those are few things. With this, I rest my thoughts, and happy to take any quick questions. Yes, please. Do we have any questions in the chat box? Are there any questions? Okay. If there are no questions, let us then request Raji to join in if he's good on time, and then he can help us in wrapping up today's session. I cannot hear you. Should we close it? Okay.